Britt Dysart is a Fredericton-based lawyer with extensive experience helping businesses and governments manage their complex affairs. He's advised on numerous IP commercialization opportunities and provided developmental and funding business advice on national and international negotiations. He's worked with businesses from all stages of development and done everything including estate planning, financing, asset lending, and more. Britt currently lends his expertise to Junior Achievement Fredericton, the Fredericton United Way, and now BioNB. He is currently a partner with Stewart McKelvey. So thank you very much for your time, Britt. I'm going to hand the controls over to you. You can take the lead.
Okay, well, Megan, thank you very much, and welcome everybody today. The title of this session is Taking Control of Your Intellectual Property, and so what I've decided to do is to address what is essentially the fundamental ways that people can lose control of their intellectual property, and that is primarily by not understanding how to commercialize properly, not understanding how to protect their intellectual property properly, and common mistakes that are made both in the development and the commercialization process. As Megan said, I will look at questions throughout, and but I have left some time at the end to sort of deal with recurring questions, so I welcome those. So with that said, I'd like to start with a very basic overview of contract. The reason for that is most agreements that people would use to protect themselves, commercialize their intellectual property, inventions and the like, are essentially contracts. And as in any contractual arrangement, there are pitfalls that can ultimately cost an inventor, a developer, or a corporation the fruits of their hard labor in terms of the invention and the development of their IP. So essentially, I'm sure you know, a contract is a legally binding agreement between two or more parties for a particular purpose. There must be an offer, there must be an acceptance, and there must be valuable consideration, services, monies passing one way or the other. But once one party voluntarily accepts an offer, then a valid contract is formed, and these can be both written and oral. Although in certain circumstances they are required to be in writing. One of the common mistakes that people make in protecting their intellectual property is relying very heavily on an agent in terms of negotiating their deals. An agent is somebody who, whether for payment or otherwise, would act for the inventor in negotiating. One has to be very careful to ensure the limit of the authority that people would have that are negotiating for them. Obviously, as well, if somebody fails to meet the terms of a legally valid contract, then that can give rise to significant monetary damages. Finally, that is very important to understand is, and this is another common pitfall in development, is courts will hold contracts to be binding even if circumstances were or not properly advised, didn't fully understand the nature and the scope of what the inventor is giving up, whether it be rights over the intellectual property, rights over using it to develop further intellectual property, or rights to royalties in terms of payment for intellectual property commercialization down the road. So contractual terms can be broken down into essentially two areas. The first would be express terms of a contract. Now, these are terms that are mentioned directly in the contract. Good examples would be price, duration of the contract, duration of a licensing agreement, and we'll get to those in a while. But implied terms in the contract would be terms of the contract. Where inventors and developers of intellectual property sometimes get in a great deal of difficulty. The implied warranties that a contract would the drafting of warranties and the implied terms is one of the key pitfalls in negotiating any intellectual property related. In addition, primary terms, most agreements of this nature, that would a court would take almost judicial notice, if I can put it that way, in terms of their common meaning at law. As well, there are terms that would be included by virtue of the patent legislation, or trademark legislation, which can be covered off very glibly by a good legal drafter, but sometimes people don't fully understand how broadly a court might interpret what is being agreed to or given up. So the issue that we always advise someone who is first of all developing and then seeking to protect and control intellectual property to make sure that they clearly understand the nature of the agreement and they fully understand the nature of the obligations and the rights and whether the certain obligations which could not be able to be met sophisticated developer. Now, in terms of the virtualization, this is the area where many people will start off wrong. They will inadvertently lose control or lose control of their property by making some very simple mistakes. However, any technology, whether it be whether it be in the biofield, whether it be that one we see advertised on TV, is essentially these commercialization agreements are all done in the same way, and the processes are generally all done in the same way. So, I think it's important to remember that successfully commercialized products can lead not only to revenue and recognition for an inventor, but they can also help advance the industry in which they are used in, and they can lead to further development opportunities for an inventor based upon the initial intellectual property development. So commercialization of a technology can essentially be achieved in two main ways. The technology can either be commercialized solely by an existing person or organization, or by spin-off or organization, which is established under that company for purposes of bringing a product to market. Each of these options, I guess, offer benefits and drawbacks. For instance, spin-offs would occur when an organization is within itself would create a new company or enter into a joint venture arrangement with a partner further developing a technology. The issue of startups, of course, you see quite a bit, certainly in Fredericton, with the platform given by a number of organizations and educational institutions. You will see startup and spin-off opportunities coming along quite frequently. However, the development of a technology by and within the existing organization or by the existing inventor does provide the benefit that existing resources that either the inventor have or the corporation for whom the inventor works made available to assist in the commercialization of the technology, such as established staff, sales channels, and development teams, which can help springboard the technology or the invention with into a strong commercialization effort. The challenge is that in many startups, the resources do not really exist to effectively deal with these issues, and the resources to acquire them on one's own can become quite expensive. And if you have a technology which is in the alpha stage, conceptual stage, or in the beta stage, which is the testing stage, it is very difficult sometimes to expend personal resources or use the resources of somebody else who may not yet understand or fully believe that the technology is commercial, can be commercialized. Notwithstanding that, either in a startup or a spin-off scenario, what often happens is instead of developing these things in-house, solely developing them, taking the time that's necessary to do it internally, parties will look to enter into some transfers of rights, and this is again where you really need to understand fully what you might be giving as you move forward, essentially to get the dollars necessary for that commercialization. So the issue really in looking at a commercialization path is which method would offer, if I could put it this way, best fit. Different technologies and different types of inventions will sometimes lead to potentially different pathways, but usually there are multiple pathways that are largely the same. So in terms of funding future development, there are clearly issues where an inventor could assign the rights to a corporation or a business that had the technological capability to essentially commercialize, and the inventor would take back either a royalty or would, in many cases, would bring this corporation. Problem with assignment and some of the others is that when these arrangements are entered into, there will be a number of collateral forms of agreement essential for any investor to secure what we would call the bundle of rights involving intellectual property. And I'll explain what the bundle of rights means very quickly. Under the law of intellectual property, especially in the area of copyright, the law creates numerous forms of rights for numerous parties. And you can understand that, especially if people are working together to create a piece of technology or an invention, that that the law would recognize that each of those parties that contributed to the development would be entitled to certain legal and equitable rights to the end product. Now, copyright law recognizes not only legal ownership, but it recognizes the concept of moral rights. And I don't think I'd have to dwell too much on legal ownership, but I think the concept of moral rights does deserve some explanation. Moral rights are, as defined by the law, the equitable right that anyone who has contributed to an invention that could be copyrighted has. So that even if a copyright, material or technology that was copyrighted is assigned or licensed, one of the rights that is never alienated would be the rights of the creator or the creators, which are the inventors, to prevent changes to that work. So it's very much, if you think about the entertainment music industry, most material, in fact virtually all material, is copyrighted. When it is sold or licensed for distribution, one of the rights of the artist or the would be the right to ensure the integrity of that invention or piece to change it. So specifically in the entertainment field industry would be just gathering royalties or versions of being created or performed. Now, that in a technology play is that a piece of technology or an invention is developed by one individual or a group of individuals. All of those individuals would have the same right to prevent alteration. Now, you can imagine in the intellectual property world that that would not be particularly palatable, mostly because of the fact that technology and intellectual property development spawn new technology and new intellectual property development daily. So the way that we try to ensure the integrity of any intellectual property that may be licensed, may be assigned, will be to recognize these moral rights and have all parties involved in the creation of the intellectual property or IP waive those rights through a specific agreement. That would allow the licensee, the assignee, what have you, to obtain the right to amend, change, develop, or create new foreground intellectual property, then commercialize and use to earn revenue for their business. So, getting into specifics, this one is probably the easiest because in the context of the title of this seminar, taking control of intellectual property, an assignment is actually where you are transferring away, and this would be the most extreme version of development. Oftentimes, what will happen in an assignment situation is an inventor will agree to a transfer of intellectual property from another. The owner of the technology retains the technology after the transfer is complete and would usually receive a lump sum payment, but in some cases, a lump sum combined with a royalty, normally based upon milestones. The only protection in there, of course, in the inventor receiving some consideration, would be if the assignee, i.e. the person who took the assignment, breaches that the technology would be automatically returned to the assignor or the inventor. It generally, a part organization or that would like this method the most. And it's also in some cases good for the inventor, because usually generate large level of compensation for because the inventor has very minimal rights. The other point here is when else can be favorable. So first time, or the first session, and the market is difficult to ask. And like I mentioned earlier, when a particular idea or piece of IP is in the alpha, the development stage, or the beta, the testing stage, which for many type of IP can take quite a bit of time. The second time, notwithstanding the state, inventor realizes that the future development costs to bring this technology to market are going to be extremely high, and a lot of that, in many cases, is due to refinement, fixing bugs, meeting regulatory standards depending on the type of IP. And these can be extremely costly and time-consuming hurdles for to jump over. Now, in terms of intellectual property, would be licensing. Now, this is the one where the whole concept of where inventor needs to be careful, because there are many different versions of a license. There are many different implications of different laws, and there are many different interpretations of what agreements mean, specifically, even depending on the jurisdiction, whether it be Canada, the U.S., European Union, etc. But generally, licensing occurs when licensor, generally the party that invented or acquired by a signed technology with an ability to license it, enters into a binding contract that grants another party the right to use this protected technology. License agreements can limit the manner in which the technology will come to some of these limitations. I've put some on the screen. First of all, the rights can be limited by territory, i.e. somebody can have the rights to a certain technology in Canada but not in the U.S. They can be limited in terms of the field of use, and a field of use would be where the technology has been identified to perhaps have several applications in the marketplace, but the licensor only wants to license one particular application to this particular licensee. A license can be limited in terms of time. In other words, it can be for a fixed period. It can be limited in terms of exclusivity or a combination of any of the above. Now, the two most common types of licenses are exclusive and non-exclusive. These are the limitations that are placed either with respect to fields of use or with respect to whether or not one is going to license all rights over the technology, its development and sale to one party. So where is granted, usually the rights are exclusive to the licensee to commercialize, to sell, in some cases to sub-license to other distributors, and in some cases to work in concert with other parties to develop improvements which the licensee would then own without further compensation, in many cases, to the licensor. This is obviously the favored method for a licensee or a transferee, simply because once an exclusive license is granted, no one else can get access to that technology. It would be favored by the partner organizations as well, because of the exclusivity, no competitor can enter in to similar agreement, and so it limits the licensee's risk in terms of expending money for further development. It's probably almost apparent to everybody that an organization that obtains an exclusive license over some technology or intellectual property is more likely to spend more resources on the development, as they are ensured that these funds are going to be put to a good use and they are not going to face competition, at least in the short term, on what they develop. However, the drawback of an exclusive agreement is that commercialization is fully based on the action of the licensee or the partner corporation. And that can have an impact on the party who granted the license, who has an entitlement to royalty fees on an annual or quarterly basis, if the licensee does not aggressively move forward and exercise its rights. However, that risk can be mitigated somewhat in the license agreement by way of establishing certain milestones which he needs to meet in order to retain the exclusive license. Now, non-exclusive licenses or agreements are essentially what they look like. A licensor would grant, usually for a limited period of time, a licensee a non-exclusive technology. What it means for the licensor, of course, is that they're free to license other parties, including the licensee's competitors. They're free to license on a worldwide basis or a limited jurisdictional basis to competitors, or they're free to license even within the same jurisdiction to competitors. The challenge for a licensee, though, in a non-exclusive situation is in most cases the licensor will retain certain rights over the technology. One of the chief rights would be the continuing right to modify the technology or to limit the application of the technology. So in that case, and in those scenarios, the non-exclusive license is a favorite of those that wish to maintain this level of control. The risk from a commercialization perspective in a non-exclusive is that the licensee is likely to put much effort into a non-exclusive license if both the jurisdiction or the territory is limited and so narrow as to development of other forms of application of the technology even within a limited jurisdiction. Now, as I said, both of these types of licensing agreements generate income through royalties and or through lump sum payments or both. It is more common that a royalty scheme would be put in place in a license, and these are essentially percentage payments of that the get at a predetermined amount on each sale of the product or the service as described in the agreement. So that for inventor, it can create a continuous revenue stream, but that revenue stream is based upon the success of the technology, And as such, this method of commercialization is ideal where the commercial viability of the technology appears to be strong, but the individual inventor either does not wish to or have the capability to bring the product to market. One thing that we always counsel a licensor to do is to attempt to include terms in the license, whether exclusive or non-exclusive, that would specifically restrict the scope of use of the technology by the licensee. And in doing so, the licensor can preserve some rights and will allow the licensor to improve the technology and evolve its potential uses. The challenge that we run into oftentimes in licenses, of course, as well, and this goes back to controlling your intellectual property, is that if at the outset of the commercialization process, an inventor does not have a clear ownership path to all of the technology or all of the property, there will be no possible. So I'll just go to the next slide. Besides licensing there are other ways in favor over the last to raise funding on a smaller scale to move forward a particular technology or piece of intellectual property. One some of you may have heard about lately is the social media method of crowdsourcing. Now, crowdsourcing has come in vogue for probably 5 or 6 years, and what it is a product which skirts the regulations of the securities commissions legally because they're not giving out shares in a company or ownership in technology for contributions. What they'll sometimes do, inventors will give out product, they will give out certain rights to subscribe if it's a new website or it's a new reusable product for fixed periods of time, but they're not giving out equity position in the owner's company. That is a precursor, of course, to the Securities Commission's regulations on raising funds. That's a way that they get around that. Now, however, as with all good things, it may come to the end. I mean, recently the Ontario Securities Commission has announced strict regulations for crowdsourcing that will come into effect that will greatly limit the amount of money per investor and or subscriber, and also will require some disclosure of research into the viability of the product. This is certainly not as strict as the requirement for raising a piece of intellectual property. In most cases, the exception of certain exceptions, the ability to do that is micro-regulation, whether it is at a first level or a secondary level of financing, or eventually going right up through to an initial offering. And as I'm sure many of you know, the complexity of that form of fundraising can be extremely difficult and extremely expensive. The other forms of finance, probably not by anybody. The first would be debt financing. Now, I mean, and that is not so different than if you get a house. You could borrow and use those funds, the money that you earn, to plug into your development project. Now, the venture is a traditional form of security for a for an investment in a company by way of debt financing. A traditional debenture would be a long-term commitment between the two parties, the lender or the borrower. And obviously, the party who receives the funds agrees to pay the money back, usually within a fixed term or over a series of installments with interest at pre-agreed intervals. The one debenture has been and still remains somewhat popular in terms of debt financing is called a convertible debenture. Now, a convertible debenture is still a secured debt obligation of the borrower. But in a convertible debenture situation, if somebody, being the lender, has lent the developer funds, they usually insist the developer be at this point a corporation, then in certain circumstances, the lender, being the debenture holder, would have the right to either demand payment or would have the right at certain determined times to into shares in the inventor developer corporation. If the convertible option is granted, that usually would give the borrower corporation a lower interest rate, but because the valuation in terms of the number of shares that a lender would get if they convert would be predetermined, unless the inventor or developer is very careful how they negotiate the terms of conversion, they find themselves losing control of their own corporation based on a subsequent valuation gain or a valuation loss. So these documents are extremely difficult to negotiate without some expert help. Usually, besides legal counsel, you would probably want to look at valuation formulas done by a chartered accountant to ensure that the conversion formulas and the conversion rates set in the convertible debenture will not inadvertently bomb you into oblivion in terms of control of your corporation as you move forward. Now, the other obvious way, and I've alluded to it, to raise capital to develop your corporation by way of financing, and this is very simple. I mean, if you incorporate a company and the company has IP protection, whether it's and intellectual property ownership, then you can both to keep involved, all through an employee stock option, and to involve institutional investors, funds or the like. So equity finance is an extremely valuable option, again, for protecting yourself and the developer. To ensure that when you're ready to sell private equity, as opposed to going through a public process, that you have very understanding and a very strong for your view of the corporation's total value. You're going to find yourself giving up a lot more of your corporation and control other than you made a bad deal. And unfortunately, that does happen quite often. The other that are extremely important would be payments, and these are collateral whether you're doing an equity financing, whether you're doing a financing, whether you're doing debt financing, whether you're just simply going to rates out, you're going to assign them. These agreements work to protect the ownership of the developer They work to protect the ownership and control of the inventor, and in most cases they help facilitate successive commercialization. The first one that we see most commonly, and I have to tell you as an aside, I beat this into my clients' heads. You never talk at all about any invention or development or improvement that you are working on, except in the broadest possible terms, unless you have non-disclosure and confidentiality agreements signed with the parties to whom you are speaking. These documents are and of them are, as I think the slide, very apparent. The process of equity finance, licensing, debt financing, and private equity financing, anyone who is going to give a developer or inventor money is going to want to know what they're using the money for. And so they're going to want to do some due diligence on the invention, on the intellectual property, on the titles of the intellectual property, and into any market viability studies or business plans that the developer or the inventor might have. The problem is this is very, very sensitive and confidential business information. It's also very sensitive intellectual property descriptions where a developer or inventor might still be in the process of securing copyright or patent rights at law. So these agreements clearly limit the dissemination of any shared confidential information and clearly must be in place before there is any sharing of information from the developer and or the investor or lender back to the developer. As I said, these can be one-way agreements or they can be mutual agreements. So a one-way agreement would be that you're looking at an investor who may have interest in the field for which the developer's technology, once commercialized, would be of value. The developer has interest to have a full and strict non-disclosure confidentiality in place, which would include prohibitions on the investor using any information, due diligence or testing for their own business purposes. Mutual agreement would be where two parties, perhaps, who all have similar or complementary technologies that may want to explore a joint venture agreement or a collaborative research agreement, which I'll touch on a little later, to jointly work on each other's related technologies, or what we would call a new foreground technology, and a foreground technology would be the improvement or the amalgamation of technology. The other key issue under the non-disclosure agreements would be the element of confidentiality and how long some agreements will last for a set period of time. Others would last longer. Some would last shorter and would expire upon the entry into of a joint venture relationship for development, on the entry in the parties entering into some form of a collaborative research. The other sort of sub to confidentiality and non-disclosures involves material transfer agreements. This is a subset which would deal specifically with what forms of transfer under the non-disclosure and confidentiality agreement information would take, and what forms and how this would be returned at the end of any due diligence period, or whether the property would simply be destroyed and have to be certified as destroyed. So, as you can see, non-disclosure and confidentiality agreements are always the first thing that a developer or an inventor is going to want to have in place as towards commercialization so that they can indeed protect their rights and not inadvertently lose them, especially in the absence of fully finalized legal IP protection. Now, you've heard me mention collaborative research agreements. These are very in a number of fields. They're often used parties, but they're also used in many cases where intellectual property has been developed and needs or another party approaches and says that we feel that we can be able, you bring your background IP, which is the existing IP the developer may have, and we bring our background IP, which is the existing intellectual property that the investor may have, and we work together to develop foreground IP, which then would be jointly owned, and each of the two parties would have certain rights to as we moved along. The collaborative research agreement would very clearly define goals. The goals would be the purpose of the collaboration, the purpose or the intended purpose and roles and responsibilities of each party in terms of the development or the improvements, and then would decide the ownership of the foreground intellectual property that was developed as a result of the successful collaboration between the two parties or more, because sometimes this is multiple. The key in a collaborative research agreement is really to capture the expectation of each party, confirm the existing ownership of IP by all parties coming to the table, what recourse would be available for breaches of the agreement, and then a clear and concise schedule of work, which would set out the expectations of the timing in which certain key items along the development milestone process are to be achieved. These do act as I on the slide, as a legally binding roadmap, and they also can predetermine and settle disputes that could arise in the future by virtue of the broad nature of rights that they tend to protect. These are usually executed after a period of due diligence, and they are usually executed only when it's mutually beneficial for both parties to move forward together. Now, one thing that I should add, and I raise this with clients, when we're talking about ownership, when we're talking about financing or debt financing, is that many developers or inventors, especially if they do a form of a spin-off or a startup where they put the technology into a corporation, miss the whole concept of conflict of interest. And conflict of interest in a commercial setting where you've entered into legally binding contracts where a number of parties have rights can be extremely expensive, because once you've entered into an agreement with another party, and especially where both parties are spending money for further development, each party has a duty not to either compete, not to use the information for their personal gain to the detriment of either of the corporations, and themselves the developer or the investor have made contradictory commitments that they put themselves in a conflict of interest. The other challenge, the other issue that we see under the conflict of interest heading is where an employee, a former employee, say of a developer, has obtained gain employment with developer or inventor, and they use it for their benefit or for another party. And that can, another party can include, and so, you know, in any situation where a developer starts to employ individuals to work further, help advance the technology that's under that is under you know, under development and one hopes will eventually be commercialized. In most agreements, including agreements, a full written disclosure of any potential conflicts to the employer or to the partner. There should be a list of any intellectual property development projects the parties are working on, so that there cannot be any undisclosed potential conflict. And there needs to be, as a spin-off to that with respect to employees, in many cases, some level of confidentiality and non-compete and non-solicitation agreement, if indeed an employee were to leave. So I touched earlier too on the agency relationship, and this is another issue I'll touch on just briefly in this context, because one of the most common mistakes, as I said at the outset, is that developers or inventors will make is they will have an advisor or advisors who will help them take decisions, or they will have employees or partners that or other shareholders that may have at least appear to have the right to make decisions on behalf of the developer. And as I said, actual or implied authority, both can lead to a developer being locked into a contract if the other side of the contract had reasonable expectation to believe that the party they signed a deal with had the ability to bind the developer. So any developer needs clearly to understand and advertise what authority key employees or partners have to bind the developer or inventor to any form of contractual agreement. And this is all for during the course of due diligence. But the other point is that an agent, be it the employer or the partner, also understand ramification agreement outside their authority, which would be a very messy legal battle. So people fail to fully express their intellectual property. There are many ways that people either succeed or fail. But some of the common ways that people fail, fully exploit the IP that they may have developed, is by unduly limiting fields of use. If you don't really, as a developer or inventor, feel you have the desire or the wherewithal to fully commercialize a piece of intellectual property, then is it in your best interest to simply provide it by way of license or assignment all fields of use to the assignee or licensee in order to maximize your potential revenue down the road? That leads into the second point, which is understanding the cost of commercialization. And in today's world, the commercialized can be costly, either in terms of hiring the key employees and paying them, but also giving them stock options in your corporation, or outsourcing the work to experts to move matters, forward towards commercialization. So there needs to be a key understanding of whether it's more beneficial to the developer to develop and commercialize the in-house, or to consider very strongly licensing it or assigning it or entering into a joint venture arrangement with a third party who can carry the load in that situation. Oftentimes as well, developers or inventors fail to understand the actual costs of licensing, and I don't just mean the cost of perhaps having to contribute to further development, but also the cost to them of the rights they give away. And this is why the area of intellectual property licensing is so very complex, and it is why you know, only I guess the most experienced of developers or inventors or corporations would enter into something like that or discussions of that nature without a clue, guiding principles and very experienced from otherwise. Finally, the biggest challenge is sometimes, and I hear this from not only investors, but I hear it from financiers of IP and technology, is that many times developers or inventors simply don't understand the costs of doing business. Oftentimes, over their head for a myriad of reasons, but many of them, in most cases, having very little to do with expending dollars towards moving towards commercialization or to move the product through the alpha, beta, and commercial stages. I think this is a common theme where perhaps the inventor or the developer is extremely creative but has not got a lot of business experience, and so that's one of the areas where they need to take some advice. And then the understand when rights need to be protected and how they have to be protected. We've covered non-disclosure and confidentiality agreements. And we've covered the fact that if you reveal too much, you can lose your technology and you can lose potential revenue. They fail to understand sometimes how to protect their intellectual property. For instance, copyright is a very strong method of protection for certain types of intellectual property. Trademark is an extremely important protection of, if I can put it this way, your design, your name, your logo, which can in and of themselves be very marketable as a brand. And as it says on the slide there, you can get an initial protection for 15 years, and that protection is renewable. And finally, patenting, you know, which is a right to exclude others from using a novel, useful, and non-obvious technology for 20 years after the patent filing. The one, going back to the cost of doing business, one thing people don't realize is in many cases the costs of obtaining certainly patents and copyright, because there can be an issue of multiple jurisdiction intellectual property which needs to be invested in, and that is usually beyond that cost the resources of an independent startup. And so one of the bases upon which partnering will occur will be to secure the economic participation of a partner or an investor to help defray some of these costs, protect the intellectual property. So with that said, I promised that I would leave minutes or 25 minutes for questions. So I guess Jenny said we have 3, so I'll get Jenny to, you want to?
Can anyone hear me?
Yep. Jenny, I think you're on mute.
Can you hear me now?
Yep.
Perfect.
You're good.
So the first question is, As a company, how can you ensure your IP is protected when working with an academic researcher? Also, is there a way to ensure you're not infringing on a patent when producing work and results for you? So just to repeat it, as a company, how can you ensure that your IP is being protected when you're working with an academic researcher? And can that company, is there a way for them to ensure that the researcher is not infringing on a patent when they're having results worked for them?
Okay, first of all, thank you for the question. Look, one of the best way, if you're working with an academic researcher, one of the keys is to understand who actually controls the rights, first off. Under many collective agreements, there are, and this would be in the university or community college sphere, academic faculty will certainly own prima facie the rights to their developments. The general rule of thumb in most collective agreements would be that that would be the case unless they have used or expended an extraordinary amount of the facilities, equipment, time, research assistance to develop the technology. But also, working with a researcher often would mean working hand in hand with with the actual institution and research office at the institution to determine exactly would have, because in many cases, and whether it be through collaborative research agreements, whether it be through things such as IRAP agreements with the government, National Research Council, this work would be funded in exchange for an assignment from a faculty member to the university by the actual institution. So I think the first thing that you need to understand is actually, you know, if work has been signed, in other words, if it's already done, because most times what will happen is that in that case the institution would have moved to secure the necessary intellectual property protection as part of taking the assignment. Development agreement that you're going to be working with an academic or faculty member on. The only way that one would be able to do that would be to look at the statement of work and then have a patent expert check to determine through patent registries whether or not it was significantly close. The challenge being oftentimes that, because patenting is very technical, is that you can't patent a full technology for existing technologies. What can only be patented is what is the novel, new, or I guess newly developed piece, which makes something work better, as opposed to, you know, starting from scratch and developing a widget, and then you could patent the widget if it didn't come. But I guess my standard response to a question like that always is this: is that you should always, in looking at any agreements and working with any researchers, seek some specific advice prior to getting into the agreement, because these, I mean, there are as many different permutations of ownership and intellectual property potential breaches as there are potential development arrangements.
Perfect, thanks. So the second question is, Should you use NDAs with everyone?
Thank you for the question. Should you use NDAs for everyone? I've been doing this for almost 30 years, and I have to tell you that I don't think I have ever seen a situation where an NDA would not be applicable. But I've seen literally hundreds of situations where an NDA would have been very helpful. I don't think I can say it any more clearly than that. Because, see, especially with non-protected intellectual property, the problem is that, you know, patenting is sort of first past the post. There are some common law rights in copyright, and there are certain, you know, rights of, you know, time of first usage, common law protections built into trademark. But the issue is sometimes it's not even as much the IP as it is the business plan and the marketing plan, which are also proprietary, that can be taken by someone who is a bit unscrupulous. So I strongly recommend them in all cases.
Good to know. We have another question here. It says, where do you see crowdsourcing going in Canada and maybe even New Brunswick specifically?
Where do I see crowdsourcing going? I see it, to be perfectly frank with you, and you know, again, it's going to depend very much on how deeply this gets regulated by governments. But you know, like if you look at you know, if you look at some of the crowdsourcing websites, I mean, you know, Kickstarter, okay, Indiegogo, you know. Kickstarter, last time I read something, I think Kickstarter had already crowdfunded over 1,400 projects from Canada, and that's just since September of last year. So let's think about that for a minute. The development level and the level of usage of crowdsourcing has been huge, and it's really on an upward trend. Now, the other big crowdsourcing site, you know, Indiegogo, is the one. It operates, I think it's around 200 countries across the world at last count, and I'm going by memory, so please forgive me, but I believe Indiegogo has said that Canada now is their second largest market after the U.S. In the world. And I do know, because I had done some research on this for another seminar a while back, that you know, the number of crowdfunding portals in Canada has jumped from about 77, or 277 rather, from about 17, I think, since 2012. And that was a statistic that sticks out in my head from the Outsourcing Association of Canada. So the reason I think it's been successful is the reason that it can continue to be successful, and that is primarily that it's cheaper, that it allows, in many cases, for the inventor or developer to continue to maintain strong ownership levels and control levels over their corporate business, but also their IP. But in the age of social media, because you're not looking at huge institutional investments, you're looking at, you know, maybe $1,000 per person. It's an extractive way to raise money over a broad spectrum of individuals, and right now it's really not regulated. But what will not necessarily hurt, but will change crowdsourcing, in my judgment, will be, as I said, you know, if the securities commissions begin to heavily regulate this in the coming year or years, then I can see, you know, there being other ways that people will move. But my sense is that they will start to regulate. As I said, the Ontario Security Commission has put out some draft guidelines for discussion, but the big problem is, of course, that the more, the more formal mezzanine financing done by sophisticated investors in terms of taking equity, and the more costly public offering lines provide much more protection for people that are being asked funds, it's the open-ended crowdsourcing market. But other than very tight regulation, I think I would expect the exponential growth levels to continue.
Is there a legal difference between the terms crowdsourcing and crowdfunding? Can we repeat it? Is there a difference between crowdsourcing and crowdfunding in a legal sense?
No, crowdfunding and crowdsourcing are really essentially the same. I mean, crowdsourcing and crowdfunding both accomplish sort of the same thing. I mean, crowdsourcing is the concept, and for instance, charities will use crowdsourcing as well, right? It's not just startups. I mean, crowdsourcing speaks to the social media phenomena where somebody is either looking to sell or collect money from a broad spectrum of individuals. So I mean, crowdsourcing is very popular within the charitable domain and the not-for-profit domain. Crowdfunding is the more specific subset, if you will, and from a legal perspective, I mean, these are not what I would call legal terms. These are more the social media term for a method of raising funds or selling services or soliciting participation. So, but in as much as the as social media does tend to define them, I would say crowdsourcing is the method. Crowdfunding would be like crowd solicitation by charities or crowd service advertising, and these all happen within the cloud, if you will, of crowdsourcing.
One final question. Some bio companies choose to protect their technology as a trade secret and don't actually pursue a patent. I'm wondering, what are the risks and benefits of doing this?
Thank you for the question. That's quite true, but it's not just bio companies. Let me give you an example. For Coca-Cola is a trade secret. It's not protected. The advantages to it are fine, as much as you're not going to run up against regulations for a public disclosure. So when you say in the bio space, it's it's an extremely diverse space. So the issue though of a trade secret protection is that the success of using that is actually boils down to how good the enterprise, the corporation are in understanding and implementing strategies to protect the trade secret. Because your only way, if it leaks out, to get protection is to go to court immediately and attempt to get an injunction and its distribution. And so in the trade secret, what we see are like rock solid confidentiality, non-disclosure agreements, prohibition agreements that would allow for obtaining of injunctive relief through a court if they were breached, and then there are other strategies, of course, wherein no one employee or no one party, except perhaps for the original developer, would understand and control or have the knowledge to decipher the property that is being protected as a trade secret. But it's a good strategy, and it works. But in order to do it properly, you really need on the forms of agreement that you want to use.
Thanks so much, Britt. We're going to wrap this up. Our thanks to Stewart McKelvey and Britt for his time, and Stewart McKelvey allowing us to monopolize your time for this particular audience. Great questions. This webinar has been recorded, and we will be posting it on our a link from our website and YouTube site. And anyone who submitted a question, we have your contact information. We'll do a draw for a gift. And the notification will go out sometime tomorrow. So as we, just a reminder we've got one more in our spring session of webinars next Wednesday at 2 p.m. What VCs are looking for in a pitch. This particular webinar will also be hosted by a VC from Montreal, Quebec, who works exclusively in life sciences and bio companies. So we're signing off now. Thanks everyone for joining us, and we look forward to seeing you all next week, or hearing you all or virtually interacting next week. Cheers.